When we talk about the concept of a government, we know that there are three major branches of the government: the legislature, the executive, and the judiciary. We also know that the legislature makes the law, the executive implements the law, and in case of any disputes or ambiguity or confusion, the judiciary will interpret the law. While this is a very simple understanding, when it comes to lawmaking, there is a little more that we can discuss. And in a previous video, I had explained the steps through which a bill becomes an act, that is, how statutes are made. And you will also remember that I explained that all statutes are laws, but all laws are not statutes. The term law includes statutes and also includes the other items that are listed in Article 13A of the Constitution, which says that law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or usage having in the territory of India the force of law. In other words, laws include the statutes which are made by the legislature. To implement these statutes, the executive makes some rules, regulations, and orders, which are also laws. And when there is a doubt, a dispute, ambiguity, or a confusion regarding the law, the judiciary will interpret the law. And this interpretation results in case laws. So, when we look at the big picture and the concept of lawmaking, the legislature, the executive, and the judiciary, all the three branches are making laws. When we look at the subject, interpretation of statutes and the principles of legislation, the interpretation of statutes part was more focused on how the judiciary interprets the laws by applying the primary rules, the secondary rules, and the presumptions. Whereas the principles of legislation part focuses on why laws are made by the legislature in the first place and the principles that influence the making of laws. Just a couple of more examples of how the judiciary and the executive influence the lawmaking process and can lead to the creation of new statutes. In 1997, while deciding on a case, the Supreme Court saw that there were no comprehensive laws to deal with situations which involved harassment of women at the workplace. So the court issued a set of guidelines which were called the Vishaka Guidelines. These guidelines not only acted as a law for a long time, they also influenced the creation of a statute, that is, the Harassment Prevention, Prohibition and Redressal Act of 2013. Similarly, for a long time, the process of commercial taxation in India was quite complicated and had started to become more and more confusing. The old system of state taxes, central taxes, value-added taxes, octroi, cess, etc. had become quite cumbersome and also had many loopholes, leading to revenue leakage. So the executive, which is the various departments and the ministries, started proposing the changes required to make the tax systems more suitable for the current social and economic environment of India. Over a period of time, these proposals and changes got consolidated and eventually became a statute, which is the Central Goods and Services Act of 2017. So, the legislature normally does not create statutes on its own. The need for the statute is usually felt by the executive or the judiciary, who initiate the process, which is then taken forward by the legislature, leading to the creation of a statute.